Good evening, everyone. Welcome to Get Set Law. We are discussing the fortnightly legal scope July, and this is our part two. So today we'll be discussing the rest of the important news, legal news from the month of July. So let's get it started. Uttar Pradesh Gangster and Antisocial Activities Prevention Act. So this is one of a unique act. So recently, Mukhtar Ansari was a ex-UP MLA, and he got this life sentence punishment, and in the case of Avdesh Narayan murder case. So Avdesh Narayan was a 32-year-old person who was got killed by the Mukhtar Ansari. And since for a long time this case was going on, and finally Mukhtar Ansari got a punishment, and even a fine of 1 lakh rupees has been imposed. So there are a few cases when the murder happens. So only in that few and rare cases the death penalty has been awarded to the convict. But in many cases, the murder's punishment rise up to the life sentence. So life sentence, the basic meaning of life sentence is that a person will be kept into the jail or kept into the imprisonment until his death. So that is called the life sentence. And this punishment has been given under the specific act of Gangster and Antisocial Activities Act. Now we will see what this act is. The Uttar Pradesh Gangster and Antisocial Activities Act was introduced back in 1986 by then Chief Minister Veer Bahadur Singh. The act consists 24 sections, and this is a small act. So, like we can see, so there's a one difference which we all of us should consider, that there is one Indian constitution which has the terminology articles. So the articles of the Indian constitution are the bare provisions, and the bare provisions of the other act of the other statutes are referred to as sections. So this we see that there are different statutes, like a criminal law. If we see in comparison to this, the criminal law IPC has Indian Penal Code has 511 sections, whereas CRPC also has close to 400 sections. So similarly, we see that the acts are quite big in the nature, but this act is small, consisting of only 24 sections. This came into force in January 1986. And the major concern, so all of us know that for what are Uttar Pradesh and Bihar is famous for. So oftentimes we heard that the mainstream criminal activities are coming from these two states. Although much development has been seen in all of these states, when these both states have come up, they have improved their image, but primarily somehow or other, unfortunately, the states were known for the different sorts of criminal activity. So that's why this was enacted in 1986, and the major purpose, major aim was to reduce the organized crime. So there are different kinds of crime. This is the organized crimes are one which are very much planned, right? And different kinds of antisocial activities. So in order to remove all of these weeds from the society, so this act was planned. Now, as per the report of the Uttar Pradesh Police, UP Gangster Act has registered 20,068 FIRs, and around 64,040 individuals have been arrested. So this was the data, the document presented by the Uttar Pradesh Police, and this is the facts and figure. This section also defines what is a gang. So gang has been defined as a group of people who are specifically getting indulged in different kind of antisocial activity. Either they might be acting individually or they might be acting collectively. But the main object, but the main purpose is to disrupt the public order, to break the public order and use violence, use riots for that specific thing by giving threat, intimidation, or doing coercion. So when one employs all of this thing to do or to disrupt a public order, so that will be called as a gang. So this thing we also see in IPC even in section 34, common intention. So common intention specifically we see in the unlawful assembly. So when we talk about section 149 unlawful assembly, it is also covered by section 34 common intention. So the same thing has been added over here, that either they might be doing individual or on an individual level, or it might be on a collective level. So both things are there, and that is why a gang is defined according to that. Next, another very important concern: do foreigners have a right to information? So this is a very genuine concern, a very genuine constitutional issue, that how far our fundamental right goes to provide the rights. So whether the rights are only available to the citizens of India, or is the right available to the foreigners also. So it is important to note that some places the word citizen have been used, in some places the word people have been used. So we will see what has been given here. So section 3 of Right to Information Act. So Right to Information Act came in 2005. So this act says that all citizens shall have the right to information. But recently a case came before the Delhi High Court where a Tibetan refugee was filing a RTI request. And the High Court considered whether a non-citizen or foreigner can also seek information under RTI or not. So basically, this kind of right is being given to the our citizens exclusively, so that they can gather the information. Because the risk lies in that if we give certain information to foreigners, that might be destructive for India as well. So Justice Pratibha Singh, who was dealing this case, she mentioned that it will be contradictory if we say that only citizens are entitled to RTI. So now she gave a reference that the purpose of RTI is to give information relating to the life or liberty, or which is a very important and distinct position. So this distinct position shall be construed in the sense that it shall not only be given to the citizen but can also be given to the foreigners as well. So now she said that, so there is a one concept called interpretation of law. So when we study interpretation of law, there are different kinds of interpretation which can be construed towards one law. So this was a positive reference. This was a positive interpretation which has been done by the Justice Pratibha Singh, and she also requested that we shall read section 3 by giving him a due positive recognition, that these are the kinds of right which this section is trying to provide. And it should not be seen as a prohibition against non-citizens. So the point was made in the sense that there could be information which is relating to the right to life and liberty, and right to life and liberty is also available to the foreigners. So considering that in mind, that constitutional aspect in mind, she was trying to say that because this is a very important thing which every citizen or even non-citizen shall also know. Now, Supreme Court has described this as a paradoxical, right? Now, the major concern is right to vote. Major concern in this topic is right to vote. Yeah, so we were discussing right to vote. Now, Supreme Court recently has outlashed because considering the fact that right to vote is yet not declared as fundamental right. So it is important to note that we have certain kinds of right. One is called as a fundamental right, another is called as a legal right, and another thing is called as a statutory right or constitutional right. So these are the different kinds of right. Now, right to vote is mere a legal right. So what status fundamental right holds is primarily of a very important nature because the fundamental rights are enforceable in the courts of law, whereas no other right is enforceable in the court of law. So if right to violate have been breached, right to vote has been violated or it has been breached by the state, then the proper recourse is not available. So that's why Supreme Court has expressed it as a matter of concern that right to vote is in a democratic state, right to vote is a very crucial component because that's how we elect our people, that's how we select our leader. And if this opportunity will not be given, then it will be a problematic case. So now that is why right adult franchise system have been brought to the place so that people can vote and the voting age has been reduced from 21 years to the 18 years. So this had a purpose that we can bring more inclusivity, we can bring more people to vote so that our democracy can be strengthened. Sorry, there was some network issue. I hope my voice and video is clear now. Okay, so democracy is one of the essential feature of the constitution, and even we can find it in the preamble also. That there are five prominent words which have been used in the preamble: socialist, secular, sovereign, democratic, and republic. So these are the five important words which have been used in our preamble, and preamble is a very important prelude to our Indian constitution. We derive our sanctity from the preamble. So that is why right to vote shall be given utmost status. The right to vote shall be given a tag of fundamental rights so that the remedies which are available under Article 32 and Article 26 for the Supreme Court and the High Court respectively of the writ jurisdiction. There are five kinds of writ for which we can apply if our fundamental rights have been violated. So this is a very important news where Supreme Court has expressed their disappointment that right to vote has still not considered as a fundamental right. Right to surveillance. Surveillance is one of the prominent issue of our country, and you all will be surprised to know that in our country, the Forbes reported that Delhi is the second city in the world who has the largest camera installed on the roads, right? So one may say the safety purposes, right? But still the purpose has not been met yet because why it has not met the purpose because the crime rates are also increasing in Delhi parallelly. So the purpose or the whole sole point is that when we are involving this quantity of the camera, it is important that the proper usage shall be done. So there are high chances where our personal liberty can be violated by the surveillance. So this has happened in the Rajasthan High Court, where High Court has expressed their concerns that without the procedural safeguard, it will offend the individual's fundamental right to privacy. So it is a very important issue where so earlier the Telegraph Act has been used of 1885, which has been used for the wiretapping or the surveillance, right? So oftentimes it might have heard, and we have seen in the movies also, that why there are no official communications made by the government officials on call, on mail, because they are prone to be surveillance. So surveillance is not only a physical surveillance or a camera surveillance, but there are e-surveillance also. Someone might be listening to your call as being a third party. So considering all of this risk, there are the official communications have been laid very less on these platforms. So Justice Birendra Kumar had noted that there are certain procedural safeguards which have been enshrined in our Indian Telegraph Act, and that needs to be followed whenever the surveillance has to be done, because procedural safeguards are a very important matter which has been given in our Article 21 also. So whenever right to life and liberty comes into the question, it is very important that the due process of law has been followed. So when we say due process of law has been followed, it means that there are certain safeguards which must have followed, but because of the procedural impropriety, the safeguards are not followed, and ultimately, as a matter of result, the rights of individual are getting violated. So this is another important issue. Right to surveillance is getting covered under Article 21. If the directions of the Supreme Court in POCL case, which have been reinforced and approved by the Apex Court in Justice K.S. Puttaswamy of India case, as well as the mandates of Act. Okay, so this specifically talks about Justice K.S. Puttaswamy, where right to privacy have been considered as a fundamental right. So any kind of physical surveillance, electronic surveillance, digital surveillance is not allowed, because that will be just will go against the case of K.S. Puttaswamy versus Union of India. So the judicial discipline also says that this kind of precedents shall be followed. The precedents do have a value of a legislative force. They do have a legislative force. So this is very important, and any kind of interception of messages is also not allowed, because it will breed the contempt and arbitrariness. Last, so new Chief Justice of Bombay High Court have been appointed. So this the appointment has been done by a central government. Devendra Kumar Upadhyay, Justice Devendra Kumar Upadhyay has been selected as the Chief Justice of the Bombay High Court. Now, it is very important to note that whenever we see about appointment, we shall also know that how appointments have been done. So appointment is done by a body called Collegium, where Chief Justice presides along with the four other senior most judges of the Supreme Court, and they give recommendations to the central government, which is approved by the government, and then these judges are appointed by the president. So it is important to understand that president is the nominal head of the country, under whose all the appointments and signs and seals and all the businesses of the government have been done. So the president appoints Chief Justice of India, president appoints Chief Justice of High Courts, right? So that value president carry. So the decision has been taken by the collegium. Collegium sends its recommendation to the government, and then finally president appoints. Justice Upadhyay graduated from Lucknow in 1991. So he was a pass out of University of Lucknow 1991, and eventually in the same year he became an advocate also. But he started practicing in 2011 in the Lucknow bench of Allahabad High Court. So till then he was practicing in the district court, and then he moved to the bench of Allahabad High Court, which is in Lucknow, and he started his practice as a additional judge in 2011, and then in 2013 he was appointed as a permanent judge. So this was the brief history of the Justice Devendra Upadhyay, and he is a very dynamic, a very learned judge who has given few good judgments in the previous times. Right? So this was all for today. We will end our session. If anyone has anything to ask, please write your comments in the comment section. Okay, so since there were no questions or no comments, so we will end the session, guys, and see you in the next week.